Hi, Jackie. This is Greg Perniuk.
Hello.
Hi. So I wanted to talk to you about a few things. Do you have some time?
Sure.
Okay. So I wanted to talk to you about your June 24th letter. This is the letter where you said you have raised other potential applications since June 1, including that you wish to be relieved of your implied undertaking to use materials in the record outside of the board proceeding and a conflict of interest application.
Right.
So that's that letter. So I wanted to ask you, can you clarify what you mean by a conflict of interest application?
That's where you've stated that your concerns with counsel being involved in your civil action and the board's work.
Right. And so, like, I obviously, as you know, I sent a previous letter earlier about that, and so Diana Richardson said you ask in an email, like she replied to this, and she said you asked for the board's opinion regarding counsel that has been retained on behalf of the respondents. Do you recall this email?
Right.
Right. So you asked for the board's opinion regarding counsel that has been retained on behalf of the respondents and chief of police and the use of the contents in the record. And then she says the board is a neutral party and is unable to provide an opinion or serve as an advocate to any party in an appeal. So I guess what I'm saying is, like, I thought that basically said that, that I can't really raise that issue. Like, I thought that basically she was kind of like saying we're not going to say anything about that. So
well, we can't give an opinion, right? We can't give a legal opinion. We're not in a position to because we're a neutral body.
Right. And so I guess I'm wondering, like, then what's the point of raising a conflict of interest application if you're not going to provide an opinion? That's kind of where I was confused about that point.
Well, you can raise it. What would happen is we would then seek the submissions from counsel.
Okay. Okay, so
we would ask them to provide their stance on it and ask you to provide yours. That's what would happen.
And then what would be the result of that? Like, I mean, like, if the board can't make an opinion, like, I guess I'm just wondering, like, if there's no real point to that, because I mean, obviously they're going to say, yeah, we don't have any conflict, and so,
right.
So I guess, is there any point to even raising that issue?
Well, it would be up to you, right? If you wish to raise the issue, then you should do so. But it would be up to you. But the board, as a neutral party, all we could do is ask everyone their position, to state their position on the record.
Right, but the board wouldn't actually have any perspective or any opinion on it.
Well, we would issue a decision, but prior to collecting submissions from the parties, there's no way we could come up with an opinion.
Okay, so the board would give an opinion if I raised.
They would put it in the application decision. It wouldn't be an opinion; it would be part of the decision.
But it would be an opinion, right?
Well, it would be a decision. We only issue decisions.
Right. Okay. I guess I can't quite see the difference between an opinion and a decision. Like, what would be a decision? Like, is a decision there is a conflict of interest? Is that like what an example of a decision would be? Like,
I've honestly never been involved in a conflict of interest decision, but our decisions are where we collect from both sides. We collect the positions, and then we are guided by the legislation, and then the board makes a decision.
Right. Okay. Right. But the decision, like, I guess, I don't know. I guess maybe, I'm sorry if I sound like I'm being pedantic or something, but I guess I just don't understand what the decision could be if, like, obviously the lawyers are going to say that they have no conflict, and the board, like, the board probably isn't going to be able to say, yes, you can't work on that lawsuit and you can't, you can choose one or the other but not both. Like, I don't think the board's going to be able to say that, right?
The courts wouldn't even be able to say that.
Really?
I don't think so. I mean, you could attempt it, but I
Right, right. And that's the thing is, I guess that's why I wanted to ask about that, simply because since Diana Richardson gave that response, and I mean, okay, I can accept that response, I understand that response, so therefore I just don't see any reason to take time at the application hearing to discuss this when it seems kind of pointless. I guess I just wanted to make sure that, I just wanted to understand that that's what you meant by the conflict of interest application. That's the thing.
Oh, we didn't mean the application. We meant that the board cannot provide an opinion.
Right. Right. And so I don't think there's any, and that's why I was wondering about that is, I don't think there's really any point discussing that at the application hearing, since I don't think it's going to have any, I don't think there's going to be any useful result. So,
okay.
So I guess what I'm saying is, I think that I'm going to cancel that conflict of interest application. I just don't see any point to it.
Okay.
Because I think that it would just, not be a useful and useful thing to discuss, I guess. Okay, so anyway, so the other question is about, you wish to be relieved of your implied undertaking to use materials in the record. And so my question to you is, how is that an application? Because, does it really need to be discussed at the application hearing? Because the application hearing is for, the additional documents of evidence, right?
Well, the application is going to be for all applications. All and any applications will be heard at the same time.
Right. So okay, go on, sorry.
So if you wish to be relieved of your implied undertaking, then that will be discussed at the hearing.
Right. And so the thing is, I guess I'm kind of surprised that this would need to be discussed at this application hearing, because what if I had asked about this after the application hearing? Would there have been another hearing just to discuss that?
No. Usually there's a deadline for when notice of applications has to happen.
Right.
So normally it's never extended to the extent it's been extended here.
Right.
Right.
So, I guess the thing is, if I had not even raised the question of using the record outside of the proceedings, if I had never raised that issue, and then after the hearing for applications, I said, you know what, I'd like to use the record outside of the proceedings, then
you would ask the board's position, and they would go and collect submissions from the parties, and then make a decision.
Okay, so then there would not have been another hearing. It would have been a different situation. It wouldn't have been a hearing.
No, it would have been probably in writing if the matter was concluded.
Right. And so, and again, I'm wondering about this simply because, why do we want to take time at the application hearing to discuss this when this really doesn't have anything to do with the appeal. It has to do with using the record, for, outside of the proceedings. So it doesn't really have to do with the appeal. So why do we want to take time at this application hearing to discuss this, I guess, is my question. And the other thing is, I didn't even, I thought that when I asked for permission to use the record outside of the proceedings, that it would be the board deciding to do that, and I didn't even, I didn't think that the respondents would have a part of that, because obviously they're going to object to it, so I don't really,
Right. Well, they're a party, right? So we always have to go to the other parties. We always have to seek. We can't just make that decision in a vacuum. So to be relieved of the implied undertaking, the board would have to know what parts of the record and for what purpose. So
it's not an all or nothing thing? It's parts of the record?
Yes.
Like, don't I just say, you know, I want to use the entire thing?
Well, I guess you could say that.
And
but the board, you know, I know of a handful of times that the board's relieved any party of an implied undertaking.
So it's actually not usually done, not usually allowed?
No.
Like even for a lawsuit? Like, you mean the board may actually, like, say, no, you cannot do that?
Right.
That's possible?
Right, because there is the implied undertaking, so to be relieved of it would be an exception.
Right. And so, and now, so so obviously I sent my letter last Friday, and I have to presume that you've read my letter, just that short little letter where I describe exactly what I believe is the respondents using the record without permission, right?
Mm-hmm. Yeah.
And so I have not read Joe Ferraco's response simply because, I mean, and you know, so, but in my opinion, they've used the record without permission. So in other words, they didn't ask
used
me.
The documents that are at PSB, right? The record is a copy of what's at PSB.
Right. So that's the source, I guess.
Right.
And
I would think so.
right. And so, I mean, and like I say, I didn't read this letter simply because everything that comes from them makes me angry, and so I thought I might as well not look at it yet. But is that basically what it says? Like, I guess I might as well open it up, right?
Sure. They've basically Mr. Ferraco stated that the LERB has no jurisdiction with respect to the civil action.
Okay. So your request, so I'm going to read, so I'm just looking at Joe Ferraco's letter here. Your request is with respect to an issue of pleadings and civil currently before the courts of Queen's Bench. I have no intention of responding to you with regard to civil action through different proceeding. This board is LERB. LERB has no jurisdiction with respect to civil action. So that's a proper response? Like, that's a sufficient response in, like, from your perspective?
I would think so. We don't have any jurisdiction. We don't have any jurisdiction over materials that are in front of the Queen's Bench.
Right. So basically, that's how they can respond. Like, they don't even have to respond to my question, and I mean, and you know,
well, he's declining to respond to your question.
Right, and they can really do that, eh? And so, and I guess.
Well, in this forum, if you want to raise it with the Queen's Bench judge, you could do that. Right,
but okay, and just to be clear, does this, like, since I asked for separate responses from Taylor, right? Does he have no obligation to respond? Like, should I respond to this and say, you know, so could I get a response from Mr. Taylor as well, or is there any point to that?
I can't think that Mr. Taylor's response will be any different.
Right.
No, the LERB does not have jurisdiction over any of the materials that's available to the Queen's Bench.
Right. So in other words, sorry to interrupt. So that's a sufficient response, in other words. Like, there's no point in me replying and saying, you know, like they can really, like, see, I don't know. This overwhelms me. Like, I feel like there's nobody on my side here. You know, like I'm up against two high-paid lawyers defending police corruption, and I'm all on my own. And I can go through and I can say that, you know what, I know perfectly well that they used my depression against me in a statement of defense, and they only got this information from the record, and I have to ask permission to use the record, but they can do it, and they don't even have to explain that. You know? Like, so.
Well, you can raise that with the board at the hearing. You can discuss that with the board.
So I can still discuss this at the hearing?
Well, you could ask the question.
Like the same question
about the implied undertaking and your concern that it doesn't apply to them.
Okay, so I can still bring this up at the hearing.
Yeah, if we're talking about the implied undertaking, then you can bring that up.
And like I can bring up Joe Ferraco's response and the fact that they.
Well, this response we're not going to put before the. You can mention that it's not properly before the board because we have no jurisdiction.
And so is there any point in me bringing up my absolute belief that they used the record without permission? Is there any point in bringing that up, or they can just shut it down? Like, is this a point of discussion?
Well, if you wish to bring it up, then you should bring it up.
and then it will be discussed, or will they just say there's no jurisdiction, we're done? Like, I don't know. I mean, I just can't believe that this is what they can get away with. Like, they don't have to explain anything. But anyways, so are you saying that I can actually bring this up at the hearing?
If we're talking about the implied undertaking, then and you're concerned that the implied undertaking applies to you, but not to, you can ask that question to the board.
Okay. Can I ask, though, for a definitive response of how they use that information in the statements of defense? Can I ask for a definitive response to that?
You might have to go to the courts for that, because we have no jurisdiction over anything that's in the statement of defense. That's not before us. They haven't seen it.
So I still have to ask for permission to use the record, but they don't. Like, they don't even have to respond. Like, they don't have to explain anything. Like, so, am I right about that? They don't have to actually explain.
Well, they would if they were obtaining the materials from the record. We don't know where they're obtaining the materials from. We're assuming it's from PSB.
Right. And okay, so like, because I pretty much asked that before, and you said that you couldn't really you couldn't comment on that.
Well, we can't really.
But you've just commented that you think that it's from PSB.
That would be my guess. The record is a copy of the materials that's at PSB.
Right. So
I'm guessing there are materials that are in common between the civil suit and this proceeding.
Right. So they can use it without permission then, because they got it from PSB. Basically, isn't that true? Like, if they
that's their client, right? Their client is the EPS, so that's.
So they can. So basically, they can use it without permission. Like, I don't know. I mean, is there any point in discussing this at the hearing? Do you think?
If you wish to, I can't tell you what you should and shouldn't make applications regarding, or what you should and shouldn't bring up to the board.
Right. Okay. Yeah, I don't know, because but I guess just from your sort of your perspective, that's where you think they got it from, just from the PSB materials.
I would think so.
And therefore that's perfectly fine. Like, in other words, they're not using it without permission because they already had it. Is that, I guess, what you're saying?
That would be my guess.
Right. And so, see, because I was talking to a friend of mine about this, right? And so, because and he was kind of saying the same thing, that he thought that that's probably where they got the materials from, is from PSB. So what I did was, I was curious about that, so I actually wrote a letter to PSB, and I said, and I used a different name because I thought there's no point in me using my real name, so I used like a fake name, and I used a different email address. And so I wrote to PSB and I asked them, if I sent a complaint to PSB and I included an Alberta Health Services document, would that document be used in any other way? Basically that's what I told them. And a person from PSB wrote back and said, we do not share information. So can I forward that communication? Like, I don't know. I just feel so overwhelmed by this, and just being, like, where the rules don't apply to them, they just apply to me, right? That's what I feel like. Like, that they can use this, and that they can use, personal documents against me in a lawsuit, and they can, and so, like, I guess I'm just wondering, is there any point in discussing that at this hearing? Like,
Well, that would be up to you. Since you're concerned about it, I think you should raise it.
Okay.
And have it discussed, because otherwise it's going to go undiscussed, and then in a few months this issue will come up again.
Right. And so now, since I wrote that letter where I explained that, is that sufficient for it being a point in the application hearing, or do I have to write another letter saying I want to discuss this at the hearing?
Yeah, you would have to. Yeah.
Okay.
Yeah, because the other parties have to be on notice that's going to be discussed.
Right. Okay. So I'm going to. Would it be sufficient for me to reply to this letter from Joe Farraco and say I wish to discuss this at the application's hearing?
Sure.
Okay. And can they object to that?
They can, but we can put it on the agenda.
Right. Okay. Well, okay, I guess. I don't know. Yep. Okay, so I guess that covers that point. Okay, but I still have to ask for permission. And do I? So, just to be clear, do I actually have to ask for permission for specific items in the record, or can I just say I am asking permission to use the whole thing?
Well, I guess if you want to use the whole thing, then that's what you're asking permission for.
Okay.
But the board they would have questions as to for what purpose.
Right. And does that mean then that I would have to justify every single piece in the record, or because my answer is I want to use this in my lawsuit, in my lawsuit I am naming the PSB detective who was supposed to be reading my complaint and who obviously didn't. He didn't personally read it. That's a fact, and therefore in my lawsuit I'm saying that. That my complaints were not addressed, and that the chief of police, said that some of them weren't even important enough that I could appeal them. Right. So in fact, the result of my complaint is part of my lawsuit. Like I amended it to include specifically the status of my complaint.
Okay.
Right. So. Sorry?
And those documents you only have through the record? You haven't obtained them in any other way?
So in my statement of claim, I specifically, because I had spoken with you before I filed my amended statement of claim, I referred to specifically the letter from the chief, right, which is obviously outside of the record.
Right.
So I referred to that letter, and that was even before I knew that I could ask for permission. So in other words, as part of my lawsuit, as part of my, the whole nature of my lawsuit has this new aspect to it, which includes the complaint, which is why I want to be able to use the entire contents of the record. So in other words, all that I have access to currently from the record is the stuff that I gave to PSB, right, which includes the redacted case files and my complaint documents, but obviously I want to use the unredacted information because there's new information there that I hadn't even, that I had no idea it existed, and also obviously I would want to use, the actual officer's explanatory reports and stuff like that, right?
Things that you would only have access to, like the officer's explanatory reports, you would have to ask to be relieved of the implied undertaking. Right. Because they waive privilege on those specifically for this proceeding.
Right. And so I guess what I'm saying, though, is that I don't, in my opinion, I want to ask for the entire contents of the record, every single page of it, for the purpose of my lawsuit, which, in fact, involves, PSB, because now they're a part of this lawsuit. So that's why it doesn't make sense to me to go through document by document what I want to ask for access to use.
Okay. Well, you can ask. You can provide notice that you're asking for implied undertaking to be relieved in respect to everything.
Right. Okay. So I guess that's what I'll do.
And they'll have their questions that they'll have to
Right. And so I guess, like, I mean, obviously, like, I mean, that's the thing is I didn't even realize that that would be part of the application hearing. So, like, I have no idea because they're going to be objecting to all of the applications that I made, I guarantee. So, you know, obviously I understand that previously you said that we would reassess how long the applications hearing would take based
Right.
on the response.
Right.
So, in other words, you know, who knows, I guess. But, yeah, I guess that's just it. I didn't even expect to be discussing the, you know, the application for the record to be part of that, and therefore, I mean, it's, you know, it's obviously going to take some time to talk about it. So, yeah, okay. So, I guess, yeah, that's what I guess, so obviously all I have to do is put in writing that I want to be, that we're going to have to discuss that at the applications hearing. But so, like, from your experience and knowledge, though, was, you know, has it been discussed at an applications hearing, or, like you say, as a submission after the hearing?
It's usually an application before, because usually the party that wants, usually they know well in advance that they want to be relieved of their implied undertaking.
Right, right. And okay, I guess, I don't know, I just feel like, you know, yeah, I guess I just feel like it just seems weird to have to discuss that at this applications hearing, but I guess we might as well just do it, I guess. Okay. So, now about making, like, so you're saying that, okay, so I've said that I want to, like, make an application to use the entire record. So if I wanted to make an application to use just parts of it, I could?
Yes, you could.
And could I do that separate from the applications hearing, or would it have to be all at that applications hearing?
Well, we're trying to streamline this, right? So
Right.
we've decided there'll be one application hearing.
Okay.
Because we don't want to be holding several application hearings.
Right. So I guess, like, for example, like I made, like, there's obviously a bunch of EPS officers involved in this series of events, right? So I made a complaint which included a few of them, and as a result of my complaint, Jeff Hood, who's a detective at EPS, reinvestigated my assault, right? So my complaint was not about him. But, like, obviously he was part of this, but it wasn't about him. But what I did was I made a separate new complaint against him in January of this year because, and so what happened was my complaint against him was just based on, like, my email communications with him and like, talking to him in person, right? But I had not ever actually seen his report, because his report was done after the redacted copies of those files were given to me. So, in other words, I have now seen his report because it's in the record, and that's the first that I've seen of it. And I want to I want to, excuse me, I want to make, like, a complaint that refers to his files in the record, right?
Right.
Because that's the only way I can actually make a complete complaint against him. So do I have to make an application just to use his files?
Yes.
Just to use, like, his...
And so you would make that application as part of your being relieved of your implied undertaking, and that would be one of the purposes, right? You would state one of the purposes is so that you can make a complaint regarding this officer.
Okay. Can I do that, like, in advance? And just, like, because the thing is, okay, so now on that note, so like I was saying, I made this complaint on January the 7th of this year, right? And so they, like, So I made that complaint, and it was a 10-page complaint, which just talked about, like I say, just the emails and the fact, and just my involvement with him personally, right? So then PSB sent me like 45-day letters, and after this complaint, and the first 45-day letter said the investigation is at the executive review stage, and then there were two other 45-day letters after that which said that the investigation is at the complaint clarification stage. And so here's the thing, is that PSB sent me a registered letter saying we have received your complaint, right? It's about Jeff Hood, specifically, this new complaint. And after that, they did not contact me. So their own process is that they're required to contact me and, and all that. And they have not contacted me at all regarding this complaint, right? So then, and because I've been, writing these documents for LERB, I have not gotten but I told them in my original complaint that I am going to send, I have not read the files, and I'm going to request those files so that I can provide more information about this complaint. So then today they sent me a letter that says the investigation is at the investigative review stage, and the results of the investigation are now being reviewed for completion. So they did their entire investigation, and it's at the investigation review stage today, but they did this without even contacting me. Not only not having the interview, which they now say I may be involved in, because they changed their letter due to my previous situation, but they have not even contacted me once about this. So I'm obviously upset about that, and the thing is that I want to be able to write a thorough complaint based on Hood's report. But Hood's report is only available in the record. So, in other words, I really don't want to have to wait until August 24th to get permission to use that report, because I've started to write my document based on that report, just because I wanted to start it, right, so that I can give it to them. And so, I'd like to be able to do that before, I don't want to take more time to, for this PSB complaint, because I wanted to follow up on that, right? So would I be able to make a separate application today to use just Hood's report?
Well, if the application were made today, even by the time we would get written submissions from parties, because your hearing is scheduled for, when is that?
August 24th.
Right.
I guess, would it make sense for me to just ask PSB if I can have permission to use that report? Because otherwise, it doesn't make sense for me not to be able to use that report to make a complaint against this detective.
Well, you may need to speak to the public complaints director of the commission.
Bonnie Bokenfor?
Yeah, Bonnie Bokenfor.
Right. So would it make sense for me to simply ask her? And then
you
she
could
might
go to her and see. I don't know if they would hold their. I don't know if they've agreed to wait for more information from you. I don't know if they'd agree to hold their process in issuing their decision or completing their investigation. I'm not sure.
Right. Right. Okay. Let's see. And it's it's a fact that I do have to ask permission to use just that report.
If it's only available in the record, yes.
Right. Okay. And so you say that that Bonnie Bokenfor would be the person to ask. She would be able to make a decision on that.
I don't know if she makes the decision. She's the public complaints director for that area for EPS. So would, I don't know. She would certainly know far better than we would.
Right. Okay. And just, I mean, just to be clear, do you think that it's kind of, I mean, is it pretty peculiar for them to, like, I'm serious, not contact me other than that first registered letter? Like, they didn't phone me or anything to ask me about if I needed any, you know, if I was going to give any extra information. Like, that's pretty peculiar, isn't it? Like, that's outside of their process.
I don't know their process.
Okay. But I mean, well, I guess I was just kind of wondering whether in your experience, if you've seen an appeal where somebody says, well, they didn't contact me at all. Because, I mean, if I really have to appeal their decision, which I will, unless the guy's fired, then that's going to be my additional kind of appeal, is they didn't even contact me.
Right.
I was just wondering whether if you've ever heard of that situation. But I mean, have you?
I don't know. Even if I don't know.
Okay, because, well, like I say, nothing. They did not contact me. They just sent out these 45-day letters, and then today I got the last 45-day letter that said, yep, we're done. You know, we're going to send this off to the chief. And it's like, well, okay, but I told you in my first communication I was going to ask for more information. So, and on that note, like, so I'm going to send them an email about this concern that they completed their investigation without contacting me whatsoever. And I was just wondering, like, I told them, because I just was talking to the investigator today, who I've never talked to before, and I said, so can I CC the law enforcement review board on this, just so that they're aware that you've completed your investigation without my participation whatsoever? So is that okay if I do CC the LERB address?
We have no jurisdiction to intervene until after when we would do our scope is very limited. We can only conduct our proceedings once the decision has been issued. We don't interfere at all with their procedures.
Right. So I guess if I could CC you, but you're not going to respond, right? Basically.
Right. We wouldn't be able to.
Right. I mean, I guess the only purpose, I was just, like, in other words, although you wouldn't respond, although the board wouldn't respond, I'd like you to, have a heads up that I'm saying this now, just like for documentation purposes, I guess.
We wouldn't even be able to document that because it's an unrelated file that we don't have before us yet.
Oh, well, okay, so
yeah. You
would pretty much delete my email.
We wouldn't have anywhere to put it, right, because it doesn't have to do with the complaint that's before us.
Right.
It would go into our non-jurisdictional material.
Right. Right. So pretty much there's no point in me even, like, having or CCing you on that email.
At this point, we couldn't state any opinion or intervene.
Like, you wouldn't even, like, keep it for purposes of, like, knowing, I guess. Like, it has no value to you, I guess.
Well, it's not necessarily even that it has no value, but it's not something we have any jurisdiction over because it's not a complaint that's before us yet.
Right. Right. Like, would you actually delete that email?
They would stay in the box. Right. But we would not put them before the board.
Right. But so in other words, like, that email probably would be part of the record produced for the appeal, I suppose.
Right. Down the line, yeah.
And so then you would have a record of it at that time.
Sure. Yeah.
Right. Most likely. Right. Huh. Okay. So, let me see here. Oh yeah, right. So, on the note of, like I was saying about asking for permission to use parts of the record. Let's see. Do I need permission to use copies of like documents if I made a complaint to the Law Society? Would I need permission to use like in other words, if I wanted to make a complaint to the Law Society where I think that the lawyers are using that information without permission, and I wanted to make a complaint to the Law Society about that, would I have to get permission to use those documents for that Law Society complaint? Like for purposes of telling them exactly what I'm referring to? Or
if you're providing any material to another party that would only be available to you through the record, you would.
Okay, because I mean, the documents that I'm talking about obviously are those Alberta Health Services documents, which I have, but
right.
The reason why I want to use the ones that are, like, I wanted to use the actual copies, like actually print them from the record so that they have the LERB or the LERB page number on them so that they know that these are actually in the record. Because obviously I can use the copies I have. So,
right.
Like I guess my question is if I sent them actual printouts that include that LERB page number for proof that they were used, is that okay? Or should I just not do that? Because I mean, they're my documents. They just have the LERB page number at the bottom.
I don't know.
Okay, so I guess.
On the one hand, those are documents available to you, but I don't know.
Right.
About materials that you're obtaining strictly from the record.
Right. Like, and that's all I'm talking about is using the actual copy simply because it has the page number, so that it's official, that I can make this complaint. Okay, I guess I'll think about that, about what I want to do there. But and how about so in the LERB record, there's a document from Alberta Justice and Solicitor General where this was part of the Victim Services Benefits application that I made.
Okay.
So there's a letter, and it's in the record, and it's only in the record. That's the only place I've ever seen it, where it says, and it's a letter from Alberta Justice to the Chief of Police, and it says, "We have received a victims of crime financial benefits application from Gregory Pernick. We require your information, etc." And so they were asking, all this, and then it says, "Please note that under the legislation, Gregory Pernick may ask to see this information either from our office or as a result of any appeals to the Crime Injuries Review Board." So now I wanted to contact Alberta Justice and Solicitor General to actually get that information, as it says in this letter, but I don't, I've never seen this letter before. So if I wanted to contact them to ask them for this information, do I have to get permission to use this copy of this letter so that they know what I'm talking about? Or would they just know what I was talking about if I phoned them?
If you've applied to the program, you should be able to contact the victims of crime, and they should have copies of the letters that they've sent you.
Right. So it's permissible for me to phone them up and read this letter to them so that they know what I'm talking about.
You could probably just give your name and they can look up they probably have a file.
Okay.
I would imagine if they've sent you letters, then they.
Right. But I guess, obviously they would have all this information. It's just that, I don't know what to ask them without reading this letter. So, is there anything illegal about me doing that? About me actually reading a letter to them? Or is
Not
that
when
you?
It's theirs.
Right.
Not when it's their letter, right? So
Yeah.
if they've sent you something, they should have records that they've sent that to you.
Right. But the thing is, they didn't send this letter to me. They sent this letter to the Chief of Police, and the only place I have it is, in this record.
Right.
I guess I'll just do it and see what happens.
But if you've applied to the program, they should have some documentation.
Right. And okay, well, I think I'll do that. Yeah, I think I'll do, like, I mean, yeah, and that's the thing is that I mean, well, who knows what the lawyers would object to, but I can't imagine they would actually object to me doing that, because this is a letter from victims, from Alberta Justice, regarding me, and I have a, so, I mean, I should be able to do that, I guess. But so, let's see. Right. And how about, like, so as I've said, I have like copies of redacted information, right? So I have the police records that are redacted, and now with the record, I have these records that are unredacted, right?
Right.
So if I wanted to, like, make a new complaint, like an actual criminal investigation against the original criminals, like the original people who had me assaulted and all that, can I use the unredacted versions of those reports? To, like, can I, like, quote them, in other words?
I don't know. You would probably want to raise that in your hearing.
Right.
The panel would be in a much better position to explain whether you're able to do that.
And the reason, like, what I'm saying is that, like, there's paragraphs that are new to me, basically, paragraphs that I would want to use, and I mean, I should be able to use them because they're within, like, it's not like I'm sending, I want to send a document to the police, and I want to refer to the files that the police wrote. So, I mean, you say that I still would have to get permission to use those redacted paragraphs? Like,
I'm not sure. You would want to explore that at your hearing.
Right.
The panel that will be there will be in a much better position to tell you what you're able to do and what you're not able to do.
Right. And so I guess just in general then, although I'm making an application to use the entire record, it's quite likely that we'll have to go through, like, document by document to ask about what I want to use.
I don't think they'll be going document by document.
You don't think they will be?
No.
Okay. So it'll be pretty much like all or nothing?
If you're asking for all of it, then that would be the focus, and they'd want to know the purpose, and they'd want to know for what reasons, and they'd want to just hear the parties' positions.
Right. Right. And so would they, like, well, I mean, guaranteed they're going to object to me using it. So if they object to me using it, is it a question of then what parts of it could be used? Or, I mean, is it, if they object to all of it, then I guess it's just kind of like a matter of discussing it.
Right, yeah. Yeah, you'd have to discuss. They would just, the board would need to know for what purpose.
Right.
And the reasons.
Right.
That should be granted.
Okay. Okay, right. So I think that's good for that. So there's one more thing. So like I was saying, I received this last 45-day letter regarding this complaint against Jeff Hood this morning, and so I called the investigator at PSB, who, like I say, has never contacted me, and I've never spoken with her before. And and I was asking her, like, as you know, in the record, there's like phone conversations between me and Jason Kowal, who was the intake guy at PSB at the time.
Okay.
And those recordings are in the record, right? So I was asking this lady on the phone this morning from PSB, and I said, so is this conversation being recorded? And she said, yes, we record all of our conversations. Well, of course, the thing is that my conversations with Jason Kowal are in the record, but my conversations with Dwayne Waffle, who is the actual investigator of my complaint, those are not in the record. And before talking to the lady this morning, I didn't realize that all these conversations were recorded. So my question to you is, therefore, my conversations with Dwayne Waffle should have been in the record because, according to this lady this morning, all the conversations were recorded.
Okay. So you could raise that at your application hearing, right?
Okay.
Because is that one of the applications that you listed? Is that you?
Well, that's the thing is that I listed one of my recordings because I recorded it, right? Because I recorded it on my end. But the thing is that according to this lady, they are required to record all their conversations, and therefore all of my conversations with Dwayne Waffle should have been in the record according to their that's the thing. Is so what I'm saying is I should make an application that all of those recordings be part of the record, simply because, according to this lady, they're all recorded.
Okay, right.
So
you have till Friday, right? So you still have time to specify that.
Right. And so, when I make that application, can I say, well, you guys recorded this, therefore you are responsible for providing it? Like, I could provide these because I just happened to record them myself, but they actually, I can say, or can I say, it's your responsibility to provide these recordings? Does that make sense?
You can make that application, yeah.
Right.
Yep, if you want those.
Okay. Okay, I guess that makes sense. Because when I received the record, I was surprised that those recordings between myself and Jason Kowal were on the record. In your experience, is that are those conversations part of the record? Like, you've seen that before?
Phone conversations, yes.
Right, between a complainant and PSB.
Right.
You've seen those in the record? Like, that's typical?
I don't know. I wouldn't have any way to gauge what's typical. I've seen them. For
Right, you've seen them, okay.
Yeah.
So I guess I will ask for that. And so in other words, like in your letter you say, written notice of these applications must be submitted with copies to counsel by no later than July 15th. And after, right. And so, in other words, I can, like you're saying, I can make other further applications.
Yes.
Like there's a couple of other things that I thought of in the meantime that I wanted to also add. So I thought I would, just write those ones up as well.
Right.
And then I guess. Okay. So I think that's everything. So yeah, I don't know. This just is astounding to me. I guess I've said that many times before, but it bears repeating. Right. So I'm going to, right. So I have until Friday to make these further applications.
Right.
Okay. Well, I guess that's everything.
Okay.
So thanks for your time again.
Sure.
Okay. Right.
All
Thanks.
right.
Okay. Bye.